Morning, are you JV Blunt? And this is cause number 26, DCCR 1220. Mr. Blunt is charged with murder in that case. Mr. Wilkerson has filed a motion asking that I reduce the bond, which is currently set at $1.5 million. And Mr. Wilkerson, you may proceed.
Yes, Your Honor. This case, Mr. Blunt has been incarcerated now since March. And with regard to his case, we are still missing evidence in terms of the whether or not well, let me put it this way: the person named in the indictment is apparently an alias of the actual victim, and so the concern at this point is, in part, a primary concern is whether or not the state could sustain a conviction as the indictment is presently worded. That being said, Judge, a $1.5 million bond does not meaningfully give Mr. Blunt the opportunity to secure bail in this case. And so, in being reasonable with the bond reduction request, given the standard bonds for offenses of this nature, we believe a bond of $750,000 would adequately secure the defendant's appearance in court.
I need some, Mr. Blunt, raise your right hand, please, the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes,
all right.
Mr. Blunt, state your name for the record, please.
JV Blunt.
You presently working?
No.
Oh, well, obviously you are presently incarcerated in Jefferson County Jail, correct? Are you able to raise funds either by borrowing or disposing of assets to make bond in the present amount of $1.5 million? Do you believe that with the help of family and potentially friends, if the court were to reduce bail in this case, that possibility might be enhanced?
Yes, sir.
Can you describe to the court your familiarity with the area? That is, do you have family here in Jefferson County?
Yes, sir.
Are you from this area?
Yes, sir.
And have you been in Jefferson County for the last 5 years?
Yes, sir. I'm thinking of my life.
All your life? Ever moved away?
Speak up, please.
No, sir.
Prior to becoming incarcerated, were you working?
Well, not right before, I had just not working in the Ford Arena.
Okay. How long had you been there?
A few months.
Are you asking this court in the interest of justice to reduce your bond from the $1.5 million that is presently set at?
Yes, sir.
Pass the witness, Your Honor.
No questions or service.
All right, any other witnesses?
No, Your Honor.
Mr. Smith, any witnesses?
No, Judge.
What is the state's position?
State is opposed to a bond reduction, Judge. It's not uncommon that bonds in murder cases are set at $1 million.
I need you to speak up too.
It's not uncommon in this court and in Jefferson County that cases for murder with facts such as these are set at $1 million or
So
like that's a sufficient bond in this case.
do you want me to take judicial notice of anything?
The affidavit of probable cause would be.
Okay, I'll take judicial notice of the court's file, including the affidavit of probable cause. Give me just a second to get that. All right, anything else?
Nothing from the defense, Your Honor.
Also, the jail records show he has disrespect for the staff and other inmates in jail while he's been.
I'll take judicial notice of, I just received a jail incident report. Has two, incident reports on it from July 15th and July 9th.
And I would just note, Your Honor, that both of them involve minor infractions. It looks like being out of bunk after lights out.
Right, this time I'm going to grant the motion to reduce the bond. I'm going to reduce the bond to $1 million. There will be bond conditions of house arrest, as well as wearing a GPS monitoring device if that bond is made. All right, we can go back with the bailiff.
Thank you, Your Honor.
Oh, there he is. All right, we're back on the record and cause numbers 26 DCCR 0322 and 0323. And so in cause number 0322, you are charged with the third-degree felony offense of assault family violence by impeding breath or circulation. That's from February 16th of 2026. What that means is that if you go to trial in that case and a jury finds you guilty, the range of punishment could be between 2 years and up to 10 years in prison. Do you understand at least the range of punishment and what could happen if you go to trial and you're found guilty?
Understand.
Okay. And then in cause number 26 DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. And do you understand that as well?
Understand.
And so I have here on the tablet those plea bargain rejections that we talked about that you've signed now with Mr. Rojas. And it looks like the district attorney's office has made offers if you wanted to enter pleas of guilty. In that first case, it would be for a 4-year term in prison. And then in the state jail, injury to a child case, it would be 12 months in the state jail. And those would run concurrently, which means together at the same time. You've got every right to reject those.
Now shifting gears to case number 2. The defendant is looking at 2 heavy charges: strangulation, assault, and injury to a child. The state offered a deal to serve for years concurrently, but he just rejected it to gamble on a jury trial interview.
Reject those offers and have your cases set for trial. Just want to go through this and make sure you do understand all of that. And you want to reject those offers and move towards a trial. Is that correct? All right, and so we'll get that done. And so Mr. Rojas is your attorney at this point. He's been appointed. Mr. Rojas can move forward with your trials, or because he handles a lot of cases for me as a court-appointed attorney, I can replace him today with a different attorney who could begin preparation for trial a little quicker. Is that okay with you, or do you want to keep Mr. Rojas?
I still want to represent myself.
Well, I understand that. So let's at least for this, if you'll indulge me at least for the beginning, so that you can take a look at all of the evidence some more with either Mr. Rojas or another attorney. Can I leave an attorney on at least till we get a little closer to trial, and then let's talk about if you really want to represent yourself when it gets closer?
Well, the question that I asked Mr. Rojas is not even answering. He's not even giving me any information that I'm seeking, like a discovery.
Right. So, well, I'm sure Mr. Rojas is relaying to you everything he can. You're not entitled to get copies of everything by law in Texas. And so he will give you copies, or whoever your attorney is will give you copies of what they can give you. Anything else they can go over with you, explain it, let you read it, but they cannot leave copies with you. So again, do you want me to appoint a different attorney and you can visit with them about your case instead of Mr. Rojas?
Is it true that you have a grand jury indictment without the person being present?
Yes.
Is that considered a waiver, you grand jury, or is that
Is it considered a what?
a waiver?
It's just how the process works.
Well, that can give me a difference, right?
All right, so Mr. Rojas will be released. We'll appoint someone today. They should be out to see you very soon to go over everything and be in preparation for trial with you, okay?
You got a name,
I don't know who it's gonna be yet. We have a list of attorneys. We'll figure that, the clerk will figure out who's next on our list, and we'll have that done today after docket, when she has some time to look at that. And so we'll let them know that you're waiting to see them. They'll be out very soon to go over everything. All right? You can go back with the bailiff. Thank you. Thank you, Mr. Rojas.
That is how a docket call goes down. We saw a murder bond drop from $1.5 million to $1 million. And a defendant rejecting a 4-year plea deal while firing his court-appointed attorney over grant. Jury misunderstandings. What do you think? Did the judge make the right call, reducing that bond?